Your patent application lacks the technical precision our clients expect, Yearsâ. They're entrusting us with protecting innovations worth millions, my senior law partner said, dismissing my work in front of a biotech CEO. The client looked uncertain, reconsidering his confidence in our firm. My partner, Michael Zhang, smiled reassuringly and opened his briefcase with practiced authority. Let me show you the patent strategy I developed for similar breakthrough technologies that achieved comprehensive protection. I sat in the San Francisco conference room, watching Michael present intellectual property work that was unmistakably mine. The innovative claim structure was mine, developed through careful analysis of prior art and technical specifications. The prosecution strategy that had overcome complex rejections was mine, created through months of detailed responses to patent examiners. The international filing approach that secured global protection was mine, based on strategic analysis I'd conducted. Even the technical understanding of the underlying biotechnology came from extensive research I'd personally performed to craft effective patent claims. This was the 19th time in 3 years that Michael had stolen credit for my patent work and positioned himself as the lead attorney despite contributing almost nothing to actual legal strategy or client service. I'd documented every instance meticulously, building comprehensive evidence. I'd gathered proof through billing records showing my hours, client communications demonstrating my relationships, patent office filings listing me as attorney of record, and colleague testimony confirming I'd handled all substantive work. Because what neither Michael nor this biotech CEO knew was that I'd already secured written commitments from 12 major clients to transfer their patent portfolios to my independent practice. I'd obtained signed statements from junior associates confirming Michael's systematic credit theft. I'd been approached by 3 prestigious IP law firms about partnership positions. I'd also consulted extensively with legal ethics attorneys who confirmed Michael had violated state bar rules and partnership agreements through his fraudulent misrepresentation. In exactly 72 hours, I would file a formal complaint with the California State Bar and dissolve our law firm partnership, revealing publicly that Michael had been claiming credit for my patent work while I actually secured the protections our clients depended on. His reputation would collapse when the legal community learned he'd built his career on stolen work. My practice would launch successfully with the clients who valued my actual legal expertise. Before we witness how a talented patent attorney whose work was stolen used bar association rules and client loyalty to destroy her fraudulent partner while building her own successful practice, I want to thank you for being part of this community. A community that believes professional fraud deserves serious consequences. A community that understands stolen credit in legal practice should be exposed and punished. If you've had your legal work stolen by partners, if you've watched colleagues claim credit for cases you handled, if you've been the invisible attorney behind someone else's success while they collected origination credit and partnership profits, this story will resonate deeply. Hit that subscribe button to join thousands who appreciate stories where documentation and determination overcome exploitation. Now let's step into the world of patent law where a brilliant attorney's work was systematically stolen by her senior partner. Where law firm hierarchies enabled ongoing fraud. Where 3 years of careful preparation created the foundation for complete exposure and justice. My name is Jessica Reynolds, and I'm a 36-year-old patent attorney originally from Boston, Massachusetts. I grew up in a family where intellectual achievement and professional excellence were valued highly. My father, Thomas, was a mechanical engineer who held numerous patents for aerospace innovations. My mother, Catherine, was a corporate attorney specializing in mergers and acquisitions. I was surrounded from childhood by discussions about innovation, intellectual property protection, and the complex intersection of technical knowledge with legal frameworks. Growing up in our Cambridge home near MIT, I spent countless evenings watching my father work on patent applications at the kitchen table. He'd spread technical drawings across the surface, explaining how each claim needed to capture the innovation's essence while distinguishing it from existing technology. I was fascinated by how words could protect inventions, how precise legal language created boundaries around intellectual property that had real commercial value. My mother contributed equally important lessons about professional integrity. She emphasized that legal work demanded absolute honesty, that an attorney's reputation depended on trustworthiness and competence. She told me stories about lawyers who'd cut ethical corners and destroyed their careers, about how professional communities valued integrity above almost everything else. Those lessons shaped my understanding of what it meant to practice law ethically. I learned about patent law when I was 16, helping my father prepare patent applications for his inventions. He taught me about claim drafting, prior art analysis, and the strategic thinking required to secure meaningful intellectual property protection. He explained that good patent attorneys needed both legal expertise and genuine technical understanding, that effective IP protection required comprehending the underlying technology deeply enough to craft claims that captured genuine innovation while avoiding prior art. My father emphasized that patent quality mattered enormously to inventors and companies who depended on IP protection for competitive advantage and business success. Poor patent work could leave innovations unprotected, allowing competitors to design around weak claims. Excellent patent work created robust protection that enabled companies to defend their market positions and realize value from research and development investment. One particular memory stands out from when I was 17. My father's team had developed an aerospace component that could significantly improve fuel efficiency. He spent weeks drafting the patent application, crafting claims that would protect the innovation comprehensively. I watched him work through multiple drafts, refining language, anticipating examiner objections, building arguments for patentability. When the patent issued 2 years later with strong claims, his company used it to negotiate a major licensing deal worth millions. My father explained that the patent's value came not from the innovation alone but from how effectively the claims protected it. That lesson crystallized my understanding of patent law's real-world impact. Good patent work created tangible business value. Poor patent work squandered opportunities. I earned admission to MIT for undergraduate studies in electrical engineering, developing strong technical foundation that would later prove invaluable in patent practice. I chose electrical engineering specifically because of its breadth, knowing it would prepare me for diverse technology areas in patent law. During my 4 years at MIT, I took courses in circuit design, signal processing, computer architecture, and semiconductor physics. But I also took biology and chemistry courses, fascinated by biotechnology's potential. I saw how electrical engineering principles applied to biomedical devices, how signal processing enabled new diagnostic tools, how understanding both engineering and life sciences created opportunities for meaningful innovation. Those interdisciplinary interests would later define my patent practice. My undergraduate thesis focused on biosensor technology, combining electrical engineering with molecular biology. I designed sensors that could detect specific proteins in biological samples, work that required understanding both electronic circuits and biochemical interactions. The project taught me how to bridge technical disciplines, a skill that became essential in patent prosecution. After graduating with honors, I attended Stanford Law School, one of the premier law schools for intellectual property. I chose Stanford specifically for its IP program and proximity to Silicon Valley innovation. During law school, I focused intensely on patent law, taking every available intellectual property course and externing at the patent office in San Jose. The externship proved transformative. I spent a semester working with patent examiners, learning how they evaluated applications, what arguments they found persuasive, what mistakes practitioners commonly made. I saw patent prosecution from the examiner's perspective, understanding their constraints and priorities. That experience made me a better patent attorney, someone who could anticipate examiner concerns and craft more effective responses. I also took courses in biotechnology law, pharmaceutical regulation, and technology licensing. I wanted broad expertise that would allow me to counsel clients on the full spectrum of intellectual property issues they faced. Stanford's faculty included practitioners who shared real-world insights about patent strategy, litigation, and licensing negotiations. During my second year, I participated in Stanford's patent clinic, representing individual inventors and small companies who couldn't afford professional patent services. I drafted patent applications, responded to office actions, and advised clients on IP strategy. The clinic gave me practical experience while confirming that patent law was my calling. I loved the intellectual challenge of understanding complex technologies and translating them into precise legal claims. I enjoyed working with inventors and scientists, helping them protect innovations they'd spent years developing. I appreciated patent law's combination of technical rigor and legal strategy, the way it required both analytical thinking and creative problem-solving. After law school, I joined a large Silicon Valley IP firm, working on patents for technology companies. The firm represented major corporations developing semiconductors, software, medical devices, and consumer electronics. I spent 5 years there, learning patent prosecution, developing technical expertise across multiple technology areas, and building strong track record of successful patent applications. The work was demanding but intellectually rewarding. I drafted hundreds of patent applications, each requiring deep technical understanding. I responded to office actions from examiners, crafting legal arguments supported by technical evidence. I counseled clients on patent strategy, helping them build IP portfolios that protected competitive advantages. I became known for handling complex biotech and pharmaceutical patents that required deep scientific understanding. While many patent attorneys focused on software or electronics, I carved out a niche in life sciences patents. I prosecuted patents for drug compounds, medical devices, diagnostic methods, and therapeutic technologies. The work demanded understanding molecular biology, pharmacology, and clinical development. I also developed expertise in patent litigation support, working with trial teams to explain technical aspects of disputed patents. I learned to present complex technology clearly to judges and juries, to identify prior art that could invalidate competitor patents, to draft claim constructions that supported our clients' positions. The litigation work taught me how patent quality mattered in disputes, how prosecution decisions made years earlier could determine lawsuit outcomes. But despite my success at the large firm, I felt constrained by its corporate structure. I wanted closer client relationships, more control over case strategy, and the opportunity to build something of my own. At 33, I decided to join a smaller boutique firm where I could develop deeper client connections and potentially make partner. I met Michael Zhang at a patent law conference in San Jose. He was 40, charismatic, running a small but growing IP firm in San Francisco that focused on technology and biotech clients. We connected during a panel discussion about patent prosecution strategy for biotechnology innovations. Michael asked sophisticated questions that suggested deep expertise. He seemed knowledgeable about the technical and legal complexities of biotech patents. After the panel, Michael approached me personally. He said he'd been impressed by my presentation, that he'd researched my background and was familiar with my successful prosecution record. He explained that his firm needed a talented patent attorney to expand their practice into biotech and pharma, offering partnership track and significant autonomy. The opportunity seemed ideal for what I wanted professionally. We met several times over the following weeks to discuss the arrangement. Michael presented himself as an experienced patent attorney with strong client relationships and business development skills. He showed me his firm's client list, revenue figures, and growth projections. Everything appeared legitimate and promising. He described his vision for building a premier boutique IP firm that combined technical excellence with personalized client service. Michael emphasized that he needed someone with my technical expertise and prosecution skills to handle the patent work while he brought in clients and managed firm operations. He acknowledged that biotech and pharma were outside his core expertise, that he needed an attorney who truly understood the science. He said he'd handle business development, client relationships, and firm management, while I'd have full autonomy over patent strategy and prosecution. The partnership structure he proposed seemed fair. I'd join as senior associate with clear partnership path within 2 years. My compensation would reflect my billable work and client origination. I'd have authority over hiring associates to support the biotech practice. Michael assured me I'd receive full credit for my patent work and client development. We agreed I'd join as senior associate with clear partnership path. Michael presented himself as an experienced patent attorney with strong client relationships and business development skills. The arrangement seemed ideal, a way to build my career while contributing to a growing firm's success. I'd handle technical patent work while Michael brought in clients and managed firm operations. It appeared to be a genuine partnership based on complementary skills. The early months were productive. I took over the firm's biotech patent practice, which had been neglected. Michael's background was primarily in software and electronics patents. He'd done little work in biotechnology and had allowed that practice area to stagnate. He was honest about this, saying he needed someone like me to revitalize the biotech practice and attract new clients in life sciences. I drafted patent applications, responded to office actions, advised clients on IP strategy. I worked long hours building the technical patent program while Michael supposedly handled business development. I developed new client presentations about our biotech capabilities, created marketing materials explaining our expertise, and reached out to my professional network to generate referrals. The work energized me. I loved the intellectual challenge of understanding complex biological innovations and crafting patent claims that protected them effectively. I enjoyed working directly with scientists and inventors, translating their technical breakthroughs into legal protection. The smaller firm environment allowed me to develop deeper client relationships than I'd had at the large corporate firm. Clients appreciated my work. I received praise for thorough applications, strategic prosecution, and clear communication about complex technical issues. Scientists told me I was the first patent attorney who truly understood their research. CEOs said my patent strategies aligned perfectly with their business objectives. The biotech practice grew rapidly based on my technical expertise and client service. Revenue from my patent work became the firm's primary income source within 6 months. My billings exceeded Michael's substantially. New clients came through my referrals and reputation. The firm's growth was almost entirely attributable to the biotech practice I was building. Michael acknowledged this privately, thanking me for transforming the firm's prospects. But I noticed concerning patterns developing. Michael would attend initial client meetings with me, sitting quietly while I explained our biotech capabilities and patent approach. Then afterward, he'd position himself as lead attorney despite contributing nothing substantive to patent strategy or prosecution. He'd describe work I'd done as our firm's approach, without clarifying I'd handled everything. During follow-up meetings, Michael would claim credit for successful patent grants that resulted entirely from my prosecution work. He'd tell clients about the strategy we developed, or our approach to overcoming the examiner's rejections, using collective pronouns that obscured the fact that I'd done all the actual legal work. Clients naturally assumed Michael, as the senior partner, had been involved in the patent strategy. The credit theft escalated systematically over the following months. Michael started telling clients he'd developed patent strategies I'd created independently. He'd claim to have prosecuted patents I'd handled alone. He'd present himself as the technical expert despite lacking deep understanding of the biotechnology involved. His misrepresentations became more brazen and specific. The first undeniable instance involved a complex biotech patent for a gene therapy innovation. The client was a biotech startup developing a novel approach to treating genetic disorders by delivering corrective genes to patient cells. The technology was scientifically sophisticated, involving viral vectors, gene expression systems, and therapeutic mechanisms that required deep molecular biology knowledge to understand and patent effectively. I'd spent months drafting comprehensive claims, conducting extensive prior art analysis, and developing prosecution strategy for the anticipated rejections. The application was technically demanding, requiring detailed understanding of molecular biology, gene delivery systems, and therapeutic applications. I worked closely with the company's scientists, learning their technology intimately, identifying the novel aspects that deserved patent protection. The patent application I drafted included independent claims covering the gene therapy vector, dependent claims covering specific embodiments and applications, and method claims covering the therapeutic process. I conducted thorough prior art searches, identifying potentially conflicting patents and publications, and crafted claims that clearly distinguished our client's innovation from existing technology. When I submitted the application to the Patent Office, I anticipated the examiner would issue rejections citing prior art references about gene therapy vectors. I prepared detailed arguments distinguishing our technology, explaining why the prior art didn't teach or suggest our specific innovations. I was ready for a complex prosecution that could take years. 6 months later, the patent examiner issued a complex rejection citing numerous prior art references about viral vectors, gene delivery methods, and therapeutic applications. The office action was 30 pages long, raising multiple grounds for rejection under different sections of patent law. The examiner questioned whether our claims were novel, non-obvious, and adequately supported by the specification. I spent weeks crafting a detailed response that distinguished our innovation from existing technologies while maintaining broad claim scope. The response required technical arguments about mechanism of action, therapeutic efficacy, and structural features that differentiated our technology. I had to explain why the prior art references, even in combination, didn't teach or suggest the specific gene therapy approach our client had invented. I worked late nights analyzing the prior art, consulting with the client's scientists to understand technical distinctions, and drafting legal arguments supported by scientific evidence. The response was over 50 pages, including technical declarations from the inventors explaining why their approach was novel and non-obvious. I submitted amendments to the claims that clarified the invention while maintaining meaningful protection. The examiner responded with another rejection, maintaining some objections while withdrawing others. I filed a second response, further refining the arguments and claim language. After multiple rounds of prosecution spanning 18 months, the patent finally issued with strong claims that provided meaningful protection. The allowed claims covered the core gene therapy innovation and important variations, giving our client robust IP protection for their technology. The client was thrilled. The patent was crucial for their business strategy, enabling them to attract investment and establish market position. The CEO called to thank us personally for securing such valuable protection. He said the patent was worth millions to the company, that investors had specifically asked about patent coverage during funding negotiations. When the grateful client called to thank us for securing the patent, Michael took the call personally in his office. I overheard him through the door, describing the prosecution strategy I developed, and my technical arguments that overcame the examiner's rejections. He accepted the client's praise without mentioning I'd handled the entire prosecution. The client believed Michael was the patent attorney who'd secured their valuable IP protection. I sat at my desk, listening to Michael claim credit for work I'd done alone. The technical understanding he was claiming to have demonstrated didn't exist. He hadn't reviewed the prior art, hadn't crafted the arguments, hadn't consulted with the scientists. He'd contributed nothing to the prosecution except his signature on firm letterhead. I felt a mix of anger and disbelief. I'd spent 18 months on this patent, working late nights and weekends, investing enormous intellectual and emotional energy. And Michael was telling the client it was his work. The injustice was staggering, but when I tried to address it, Michael dismissed my concerns completely. I confronted Michael about the misrepresentation immediately after he finished the call. I walked into his office and asked directly why he'd claimed credit for prosecution work I'd handled entirely alone. Michael looked surprised by my directness, as if he hadn't expected me to challenge him. He recovered quickly, offering an explanation that sounded reasonable but was fundamentally dishonest. He said clients appreciated having the firm's senior partner personally involved in their matters, that had built confidence. He claimed that distinguishing between which attorney handled specific tasks was unnecessarily complicated and could undermine client trust. He suggested I was being territorial about individual credit when we were building the firm together as a team. "Jessica, we're a partnership," Michael said smoothly. "Clients don't need to know every detail about internal work division. What matters is that the firm delivered excellent results. You handled the technical work beautifully, and I managed the client relationship. That's how effective law firms operate." I pushed back, explaining that claiming to have developed prosecution strategies he didn't create was fundamentally dishonest. I pointed out that professional ethics required honest communication about attorney qualifications and work. Michael waved away my concerns, saying I was overreacting and needed to understand how senior partnerships functioned. "You're still thinking like an associate," he said dismissively. "When you make partner, you'll understand that the firm's reputation matters more than individual attribution. Clients hire the firm, not individual attorneys. We share credit for collective success." The conversation left me frustrated and concerned. Michael's explanation sounded plausible on the surface but felt wrong. I knew the difference between reasonable collective credit and fraudulent misrepresentation. Claiming to have personally developed prosecution strategies, you had no role in creating crossed ethical lines. But I was new to the firm, uncertain about challenging my senior partner more aggressively. Over the following months, the pattern intensified. Michael claimed credit for additional patents I'd prosecuted, presenting my work as his own during client calls and meetings. He started describing himself in marketing materials as an expert in biotech patent prosecution, listing technical areas where his expertise came entirely from my work. The second major incident involved a pharmaceutical patent for a novel drug compound. Our client had developed an innovative small molecule that showed promise for treating neurodegenerative diseases. The chemistry was complex, requiring understanding of medicinal chemistry, structure-activity relationships, and pharmacology. I'd worked closely with the client's chemists to understand the compound's structure, mechanism of action, and therapeutic potential. I drafted patent claims covering the compound itself, pharmaceutical compositions containing it, and methods of using it therapeutically. The application required sophisticated chemical nomenclature and detailed description of the compound's properties. During patent prosecution, the examiner rejected the claims as obvious over prior art compounds with similar structures. I had to craft arguments explaining why our specific compound wasn't obvious despite structural similarities to known molecules. The arguments required deep understanding of medicinal chemistry, demonstrating that small structural changes produced unexpected therapeutic properties. I spent months developing these arguments, consulting with the client's chemists, and gathering experimental data showing the compound's superior properties. The prosecution was technically and legally complex, requiring me to become deeply knowledgeable about neurodegenerative disease mechanisms and drug development. When the patent finally issued, protecting the client's innovative drug compound, Michael presented it at a firm meeting as a pharmaceutical patent I recently secured through strategic prosecution that overcame difficult obviousness rejections. He described the technical arguments I'd developed as his own work, explaining to the assembled attorneys how he'd distinguished the compound from prior art. I sat in the meeting, listening to Michael present my work as his accomplishment. Other attorneys asked him technical questions about the chemistry and prosecution strategy. Michael answered by rephrasing explanations I'd given him previously, presenting my expertise as his knowledge. No one questioned his claims because he was the senior partner and I was still technically an associate. The third incident involved a diagnostic patent for a medical device company. They'd developed a novel biosensor technology for detecting disease biomarkers in blood samples. The technology combined microfluidics, electrochemistry, and molecular biology in innovative ways. I'd drafted patent claims covering the device, the detection method, and the specific biomarker panels. The application required understanding electrical engineering, chemistry, and molecular diagnostics. During prosecution, I had to overcome rejections based on prior art biosensors, crafting arguments about why our specific combination of features was non-obvious and provided unexpected advantages. When the patent issued, Michael told the client during a congratulatory call that he'd personally guided the prosecution strategy and developed the technical arguments that secured your valuable IP protection. The client thanked Michael enthusiastically, believing he was the attorney who'd understood their complex technology and protected it effectively. I realized Michael's fraud was systematic, not occasional. He was building his professional reputation on my work, positioning himself as a biotech patent expert based entirely on expertise I'd developed. He was deceiving clients about who actually handled their legal matters, violating basic professional ethics about honest communication. But the most egregious incident occurred when Michael spoke at a major intellectual property conference about biotech patent prosecution strategies. The conference was attended by hundreds of patent attorneys from across the country. Michael was invited to present based on his supposed expertise in biotechnology patents, expertise that existed only because of work I'd done. I attended and watched him present my patent strategies to hundreds of IP attorneys. He described techniques I'd developed for overcoming obviousness rejections in pharmaceutical patents. He explained approaches I'd created for crafting broad claims in biotech applications. He discussed methods I'd innovated for prosecuting diagnostic device patents. The presentation was essentially a summary of my prosecution work, presented as his expertise. Michael showed slides with examples from actual patent prosecutions I'd handled. He described technical arguments I'd developed, explained legal strategies I'd created, discussed results I'd achieved. The audience asked sophisticated questions that Michael answered by rephrasing explanations I'd given him during our internal case discussions, presenting my technical knowledge as his understanding. Colleagues from law school attended the conference and messaged me confused afterward. They recognized my prosecution style in Michael's presentation. They knew my technical background and expertise. They questioned why Michael was claiming work that seemed inconsistent with his known skills and experience. The professional embarrassment was significant and humiliating. One former classmate, Sarah, called me that evening. "Jessica, I attended Michael's presentation today," she said carefully. "A lot of what he described sounded exactly like approaches you developed when we worked together in the Stanford Patent Clinic. The biomarker detection strategies, the pharmaceutical obviousness arguments. Those were your innovations. Why is Michael claiming them?" I didn't know how to respond honestly without criticizing my senior partner publicly. I offered vague explanations about firm collaboration and collective work product. Sarah didn't seem convinced. "I've known you for years," she said quietly. "I recognize your work. If something inappropriate is happening, you should document it and protect yourself." Her words crystallized something I'd been avoiding confronting directly. Michael wasn't just taking convenient credit during client calls. He was systematically building his professional reputation on my work, presenting my expertise as his own to the entire IP community. The fraud was comprehensive and deliberate, not accidental or casual. But beyond the conference presentation, Michael's credit theft extended into the firm's business development. When prospective clients contacted us about biotech patents, Michael would meet with them personally and describe his successful prosecutions and his technical expertise, citing work I'd actually performed. New clients hired the firm believing Michael was the expert biotech patent attorney. During one particularly galling incident, Michael met with executives from a pharmaceutical company seeking patent counsel for their drug development pipeline. I sat in the meeting while Michael described his experience prosecuting pharmaceutical patents, citing specific examples from my work. He explained technical aspects of drug patenting using knowledge I'd developed, answering the executives' sophisticated questions with information I'd taught him. The executives were impressed. They asked Michael detailed questions about patent strategy for their specific compounds, questions that required genuine pharmaceutical expertise to answer competently. Michael answered using fragments of conversations we'd had about other clients' drugs, repurposing my insights and presenting them as his own thinking. After the meeting, the pharmaceutical executives hired our firm specifically because they believed Michael possessed deep pharmaceutical patent expertise. The engagement letter listed Michael as lead attorney. When I handled all the actual patent work for their compounds, the clients believed Michael was supervising and guiding my efforts, when in reality he contributed nothing to the technical or legal strategy. This pattern of credit theft affected my professional development directly. When clients praised the firm's patent work, they directed that praise to Michael. When referrals came from satisfied clients, they asked specifically for Michael. When the firm's biotech practice gained recognition in legal publications, Michael was quoted as the expert. My actual contributions remained invisible to the outside world. The invisibility mattered enormously for my career. Patent law is a relationship-driven profession where reputation and client loyalty determine success. Attorneys build careers on demonstrated expertise and client satisfaction. Michael was systematically capturing both, building his reputation on my work while preventing me from establishing my own professional identity. I also discovered financial improprieties related to the credit theft. During a routine review of firm billing records, I noticed irregularities in how client origination credit was allocated. Under our partnership agreement, attorneys received origination credit for clients they brought to the firm, credit that affected compensation and partnership decisions. Michael had assigned himself origination credit for biotech clients I'd actually brought in through my professional network and referrals. Clients I'd known from my previous firm, scientists I'd met at conferences, companies that hired us specifically because of my expertise were all listed in firm records as Michael Origination. The financial implications were substantial because origination credit determined year-end bonuses and partnership equity. When I questioned the origination assignments, Michael claimed that since he'd attended initial meetings or signed engagement letters, he deserved origination credit regardless of who actually brought the client to the firm. His interpretation was self-serving and contradicted standard law firm practices where origination credit goes to the attorney who generated the client relationship. The billing irregularities extended beyond origination credit. I discovered instances where Michael had recorded billable time on matters I'd handled entirely alone. His time entries were vague, describing patent strategy or client consultation on cases where he'd contributed nothing substantive. The billing inflation allowed Michael to maintain higher billable hours than his actual work justified. These discoveries transformed my understanding of the situation. Michael wasn't just taking convenient credit during occasional client interactions. He was systematically defrauding clients, the firm, and me through false billing, misappropriated origination credit, and comprehensive misrepresentation of his role and expertise. During those 3 years, I systematically documented everything while building my exit strategy. I recognized that confronting Michael directly would accomplish nothing. He'd dismissed my initial concerns and intensified the fraud. The only effective response was building irrefutable evidence and planning strategic departure that would expose his dishonesty while protecting my career and clients. I maintained comprehensive billing records proving my work on every matter. I kept copies of all patent applications I'd drafted, office actions I'd responded to, and client communications I'd handled. I saved emails showing my technical analysis and legal strategy. I preserved internal memoranda demonstrating that I'd developed prosecution approaches Michael later claimed as his own. I also began documenting Michael's misrepresentations methodically. When he claimed credit during client calls, I recorded dates, clients, and specific false statements. When he presented my work at conferences, I saved his presentation materials and attendee communications. When he misallocated origination credit, I documented the actual client relationships with supporting evidence. The documentation phase was emotionally exhausting. Every instance of credit theft hurt personally and professionally. Watching Michael build his reputation on my work while preventing me from receiving deserved recognition was profoundly demoralizing. I questioned whether I should have joined the firm, whether I'd made a terrible career mistake. But the documentation also empowered me. Each piece of evidence made the case against Michael stronger. Each false claim he made could be disproven with contemporaneous records. Each client he deceived could be shown the truth. I was building a comprehensive case that would destroy his fraudulent reputation while validating my actual contributions. Beyond documentation, I began strengthening my independent client relationships. I made sure clients knew I was handling their patent work personally. During calls and meetings, I subtly emphasized my role without directly contradicting Michael's claims. I sent clients detailed updates about patent prosecution, technical analysis, and legal strategy from my email address, creating records of my direct involvement. I also started networking more actively within the biotech and pharmaceutical industries. I attended scientific conferences where I could meet potential clients and build relationships independent of the firm. I published articles about patent strategy in industry publications, establishing my expertise publicly. I volunteered for intellectual property associations, raising my profile in the legal community. These networking efforts had dual purposes. They positioned me for eventual independent practice while creating documented evidence of my expertise and reputation separate from Michael's false claims. When the time came to leave the firm, I'd need clients to understand that I was the attorney who'd actually handled their patent work. I gathered client communications showing my relationships with the scientists, executives, and inventors I'd worked with over 3 years. Email exchanges where clients asked me detailed technical questions, thanked me for excellent patent work, and requested my specific involvement in their matters. These communications proved that clients valued my expertise and wanted me as their patent attorney, regardless of Michael's false claims about his role. I also secured commitments from 12 major clients willing to transfer their patent portfolios to my independent practice when I left the firm. These conversations were delicate, requiring me to signal my plans without explicitly recruiting clients while still employed. I approached clients I had strong relationships with, explaining that I was considering starting my own practice and asking if they'd be interested in continuing to work with me. The responses were overwhelmingly positive. Clients told me they'd hired the firm because of me specifically. They said they valued my technical expertise and wanted me to continue handling their patent work. Several clients explicitly stated they'd been frustrated with Michael's minimal involvement and preferred working directly with me. These commitments gave me confidence that independent practice was viable and that clients would follow me. I also began consulting with legal ethics attorneys who specialized in partnership disputes and professional responsibility. I needed expert guidance about the legal and ethical issues involved, both to protect myself and to understand options for addressing Michael's fraud. The consultations revealed that Michael had violated multiple professional rules and provided strong grounds for action. The ethics attorneys confirmed that Michael's conduct violated California state bar rules in several ways. Making false statements about qualifications or services violated Rule 7.1 about communications concerning attorney services. Claiming credit for work he didn't perform violated duties of honesty and candor. The billing irregularities potentially violated rules about fee arrangements and client property. The attorneys also explained that Michael's conduct violated our partnership agreement. The agreement required honest accounting of billable hours, accurate assignment of origination credit, and truthful representation of attorney contributions. Michael's systematic fraud breached these contractual obligations, giving me grounds to dissolve the partnership and potentially sue for damages. Most importantly, the ethics attorneys confirmed that I could file a formal complaint with the California State Bar alleging Michael's professional misconduct. The bar takes fraud seriously, particularly when it involves deceiving clients about attorney qualifications and services. A substantiated complaint could result in disciplinary action ranging from public reprimand to license suspension, destroying Michael's legal career. The possibility of bar discipline was the leverage I needed. Michael cared intensely about his professional reputation and standing in the legal community. The threat of public exposure and bar sanctions would force him to negotiate honestly about partnership dissolution and client transitions. Without that leverage, he might fight my departure and try to retain clients through continued misrepresentation. I also received offers from 3 major IP firms interested in hiring me as partner based on my demonstrated expertise and client relationships. The offers validated my value independent of Michael's firm and provided alternative paths if needed. Knowing I had other options gave me confidence to plan my departure strategically rather than feeling trapped. The first offer came from a prestigious Silicon Valley IP firm that represented major pharmaceutical and biotech companies. They'd been tracking my prosecution successes and heard positive feedback from clients and colleagues. They offered me partner position with attractive compensation, full support staff, and autonomy over my biotech practice. The offer confirmed that the IP community recognized my expertise despite Michael's credit theft. The second offer came from a boutique life sciences law firm in San Francisco that specialized in emerging biotech companies. They wanted someone with my technical background and prosecution experience to expand their patent practice. They offered equity partnership with the potential to build and lead their patent prosecution group. The opportunity appealed to my entrepreneurial interests and desire to build something significant. The third offer came from a major international IP firm with offices worldwide. They wanted to strengthen their West Coast biotech patent practice and saw me as the ideal attorney to lead that expansion. They offered generous compensation, international practice opportunities, and substantial resources. The offer validated that my expertise was valued at the highest levels of patent practice. These offers were gratifying professionally but also strategic. They gave me negotiating leverage with Michael and confidence that I could succeed independently. I didn't accept any of the offers immediately, instead using them as evidence that I had viable alternatives to staying at Michael's firm. The offers proved I wasn't dependent on him and could build a successful career regardless of his cooperation. After 3 years of careful documentation and preparation, I had everything needed to act. I had comprehensive billing records proving I'd handled all substantive patent work Michael claimed as his own. I had client commitments from 12 major companies willing to transfer their portfolios. I had colleague testimony from junior associates willing to confirm Michael's systematic fraud. I had legal ethics opinions documenting bar rule violations. I had a drafted bar complaint ready to file. The foundation was solid and comprehensive. I also had financial analysis showing that I could launch a successful independent practice. I'd calculated startup costs for office space, support staff, technology infrastructure, and professional insurance. I'd projected revenue based on committed client portfolios and expected new business. The numbers showed that independent practice was not only viable but potentially more profitable than staying at Michael's firm while he took credit for my work and diverted my compensation. The emotional preparation was equally important. I'd processed the anger and hurt from 3 years of exploitation. I'd moved beyond feeling victimized to feeling strategically powerful. I had evidence, leverage, committed clients, and professional options. Michael's fraud had given me the motivation and justification to destroy his reputation while building my own successful practice. I was ready to act decisively. I scheduled a meeting with Michael, arriving with my attorney who specialized in partnership disputes and legal ethics. I'd hired her weeks earlier, briefed her comprehensively on the situation, and developed a detailed negotiation strategy. Her presence would signal the seriousness of my intentions and provide legal protection during the confrontation. Michael looked surprised when I arrived with legal counsel, his expression shifting from casual greeting to concerned confusion. "Jessica, what's this about?" he asked, gesturing toward my attorney. "Why do you need a lawyer for a partner meeting?" "Michael, this is Karen Stevens, she specializes in legal ethics and partnership law," I said calmly. "I've asked her to join us because we need to discuss serious professional misconduct that's occurred over the past 3 years. Please sit down so we can address this comprehensively." Michael's face went through several expressions quickly, concern to defensiveness to attempted dismissiveness. Professional misconduct? Jessica, if this is about credit attribution again, I thought we'd settled that. We're building the firm together. There's no misconduct involved in normal partnership operations. Karen intervened before I could respond. Mr. Zhang, I've reviewed extensive documentation of systematic fraud involving false claims about patent work, billing irregularities, misappropriated origination credit, and client deception. This goes far beyond normal partnership dynamics. We're here to discuss resolution of these violations before they become public through bar disciplinary proceedings. The mention of bar proceedings changed Michael's entire demeanor. His casual dismissiveness disappeared, replaced by visible anxiety. He understood immediately that this wasn't a routine partnership disagreement but a serious professional crisis. Bar proceedings? What are you talking about? There's been no fraud or deception. I opened my briefcase and began laying out evidence systematically. First, I presented billing records showing that I'd performed all substantive work on dozens of patents Michael had claimed as his prosecutions. The records showed thousands of hours of my time drafting applications, analyzing prior art, crafting office action responses, and conducting client consultations, compared to minimal logged time from Michael. These billing records prove I handled complete prosecution of 63 patents you've publicly claimed as your work, I explained methodically. You've told clients you developed prosecution strategies, overcame examiner rejections, and secured patent protection. The billing records show you contributed almost no substantive time to these matters. That's fraudulent misrepresentation. Michael tried interrupting, but Karen raised her hand. Let Ms. Reynolds present the evidence completely before you respond. You'll have full opportunity to address the allegations. Next, I presented client communications proving my relationships and technical work. Emails where clients asked me detailed scientific questions, thanked me for excellent patent analysis, and requested my involvement in strategy decisions. Communications that demonstrated clients worked with me directly on technical and legal matters, contradicting Michael's claims of having handled the patent work. These communications prove clients worked with me as their primary patent attorney, I continued. They came to me for technical expertise, legal strategy, and prosecution guidance. Yet you've told these same clients that you developed their patent strategies and handled their prosecutions. That's client deception. I then presented evidence of Michael's conference presentation claiming my work as his expertise, including the presentation slides and attendee communications questioning the attribution. I showed marketing materials where Michael described himself as a biotech patent expert based entirely on work I'd performed. I demonstrated the systematic nature of his fraud, not isolated incidents but comprehensive misrepresentation. You've built your professional reputation on my work, I said directly. You've presented my patent strategies at conferences. You've claimed my technical expertise in marketing materials. You've positioned yourself as a biotech patent expert when that expertise exists only because of work I've done. That's professional fraud. Finally, I presented the billing irregularities and origination credit misappropriation. Documented instances where Michael had assigned himself origination credit for clients I'd brought to the firm through my relationships and referrals. Cases where he'd billed time for work I'd performed alone. Financial fraud that had directly affected my compensation and partnership prospects. You've systematically misappropriated origination credit and inflated your billable hours, I explained. Clients I brought in through my professional network are listed as your originations. Time I spent on patent work is recorded as your billable hours. That's billing fraud and partnership agreement violations. The evidence was overwhelming and methodically organized. Karen had helped me arrange it for maximum impact, presenting the fraud's comprehensive nature. By the time I finished, Michael looked shaken and cornered, understanding that his systematic deception had been thoroughly documented. Michael tried defending himself, but his explanations sounded hollow against the comprehensive evidence. He claimed normal partnership dynamics and collective credit, arguing that senior partners naturally receive credit for firm work. He suggested I was misunderstanding law firm culture and overreacting to standard practices. Jessica, you're making this sound like deliberate fraud when it's just how law firms operate, Michael argued weakly. Senior partners guide firm strategy and receive credit for collective success. That's not misconduct, it's normal professional structure. You're still thinking like an associate instead of understanding partnership dynamics. Karen interrupted him sharply. Mr. Zhang, claiming to have personally prosecuted specific patents you didn't work on isn't partnership dynamics, it's fraud. Telling clients you developed prosecution strategies you had no role in creating violates bar rules about honest communication. Billing hours for work you didn't perform is theft. These aren't cultural misunderstandings, they're serious professional violations. Michael shifted tactics, trying to minimize the misconduct's severity. He acknowledged there might have been communication issues about work attribution but claimed no harm was done because clients received excellent service regardless of which attorney performed the work. He suggested we could clarify attribution going forward without needing dramatic actions. Even if there were some misunderstandings about credit, no clients were harmed, Michael argued. They got great patent work, which is what matters. We can improve our internal communication about attribution without involving bar associations or making this a crisis. This seems like an overreaction to minor attribution issues. I responded firmly, maintaining calm but making the seriousness clear. Michael, you've systematically deceived clients about who handled their legal work. You've violated professional ethics rules about honest communication. You've breached our partnership agreement through billing fraud. This isn't about communication issues or attribution preferences. You've committed comprehensive professional fraud. Karen then presented the drafted bar complaint, explaining the specific rule violations and potential disciplinary consequences. She walked Michael through each allegation methodically, showing how the evidence supported charges of client deception, billing fraud, and professional misrepresentation. She explained that the California State Bar takes such violations extremely seriously. Rule 7.1 prohibits false or misleading communications about attorney services, Karen explained. Claiming to have prosecuted patents you didn't work on violates this rule. Rule 1.5 requires honest fee arrangements and billing. Recording time you didn't work violates this rule. These violations, supported by the documentary evidence Ms. Reynolds has gathered, would likely result in public discipline including possible license suspension. The mention of license suspension clearly terrified Michael. Patent attorneys depend on bar licensure for their careers. Public discipline would destroy his reputation in the IP community. Suspension would end his practice. He understood suddenly that this wasn't a negotiable partnership disagreement but a genuine professional crisis that could end his legal career. When Michael fully understood the seriousness and the strength of my evidence, his demeanor shifted from defensive to desperate. He became anxious and angry simultaneously, cycling between pleading for understanding and making implicit threats. He suggested I was being vindictive, that filing bar complaints would hurt both our reputations, that we should work out our differences privately. Jessica, think about what you're doing, Michael said, his voice tight with stress. Filing bar complaints will create a scandal that affects both of us. Clients will question the firm's stability. The IP community will hear about partnership disputes. This could damage your career as much as mine. We should resolve this privately and professionally. I responded calmly but firmly. My career will be fine, Michael. I have committed clients who want to work with me. I have job offers from major IP firms. I have documented expertise and reputation. What I won't do is continue allowing you to build your reputation on my stolen work while deceiving clients about who actually handles their legal matters. Michael then tried a different approach, suggesting that I couldn't take clients when I left because they were firm relationships, not personal ones. He claimed contractual restrictions prevented me from soliciting firm clients. He threatened to fight my departure expensively through litigation if necessary. The clients are firm relationships, Michael insisted. You can't just take them when you leave. There are contractual restrictions against soliciting clients during and after employment. If you try to leave with client portfolios, I'll fight that through every available legal channel. The litigation will be expensive in public. Karen smiled slightly, clearly having anticipated this argument. Mr. Zhang, clients have the right to choose their attorneys. Ms. Reynolds hasn't solicited clients, they've independently expressed willingness to continue working with her. Given that you've systematically misrepresented who actually handled their patent work, any attempt to prevent client transitions would likely fail. Moreover, litigation would provide an excellent forum for publicly exposing the fraud you've committed. She paused, letting that sink in. We'd welcome bar proceedings where comprehensive evidence of your misconduct would be presented publicly. Discovery would be extensive, revealing every false claim you've made, every client you've deceived, every billing irregularity you've committed. The IP community would learn that you built your reputation on stolen work. Is that really the outcome you want? The threat of public exposure through either bar proceedings or litigation clearly frightened Michael more than anything else. His professional reputation was his most valuable asset. Public revelation of systematic fraud would destroy it completely, ending not just this partnership but his entire legal career. No clients would trust an attorney exposed as having built his reputation through comprehensive deception. Michael's resistance collapsed as he understood he had no viable defense and everything to lose from public exposure. He asked what I wanted, what it would take to resolve this privately without bar complaints or litigation. His tone shifted from threatening to negotiating, acknowledging implicitly that he was in a position of weakness. What do you want from me? Michael asked quietly, his earlier bluster gone. What resolution are you seeking? I outlined my terms clearly. I would buy out Michael's partnership interest at fair valuation reflecting his actual contributions, not the inflated value created by my stolen work. He would acknowledge in writing that I'd developed the biotech practice and handled the patent work he'd falsely claimed. He would agree never to make false claims about having prosecuted patents I'd handled. He would sign comprehensive non-disparagement agreements preventing him from damaging my reputation or new practice. I want to purchase your partnership interest at a valuation that reflects your actual contributions, I explained. Given that the firm's value comes primarily from the biotech practice I built and the client relationships I developed, that valuation will be modest. You'll acknowledge in writing that I developed the firm's biotech capabilities and handled the patent prosecutions. You'll agree to cease all false claims about having prosecuted work I performed. Michael objected weakly to the valuation, claiming his business development and management contributions deserved more value. But Karen pointed out that most clients had come through my referrals and that his management had primarily consisted of taking credit for my work. The evidence didn't support significant valuation for his contributions. We negotiated for hours, with Michael gradually accepting that he had little bargaining power. The comprehensive documentation and threat of bar discipline left him few options beyond accepting my terms or facing career-destroying public exposure. He tried to negotiate better financial terms, but the evidence of his minimal actual contributions undermined those efforts. After extensive difficult negotiation, we reached settlement. I would buy out Michael's partnership interest at a valuation reflecting his genuine contributions, significantly less than he'd hoped but more than his fraud deserved. He would acknowledge in writing that I'd developed the biotech practice and handled the patent work. He would agree never to make false claims about having prosecuted my patents. He would sign non-disparagement agreements. The written acknowledgement was particularly important. It created a legal record admitting the truth about who had actually built the firm's biotech practice and prosecuted its patents. If Michael ever tried to claim credit for my work again, this document would provide immediate proof of his dishonesty. The acknowledgement protected my reputation and validated my contributions. Michael signed the settlement agreement reluctantly, understanding he had no better option. He looked defeated and bitter, finally confronting consequences for 3 years of systematic fraud. As he signed each document, I felt a mix of satisfaction and sadness. Satisfaction that justice was finally occurring, sadness that this professional relationship had been built on exploitation rather than genuine partnership. Karen had one final requirement before we concluded. She insisted that Michael provide written statements to the 12 clients who'd committed to following me, acknowledging that I'd handled their patent work and that they were free to choose their attorney going forward. These statements would prevent any future claims that I'd improperly solicited clients or that clients were confused about who had performed their legal work. Michael resisted initially, but Karen explained that without these statements, the settlement agreement would fail and we'd proceed with bar complaints. Michael reluctantly agreed, drafting letters to each client acknowledging my role in their patent matters and confirming their right to select counsel. The letters were honest in ways Michael had never been during our partnership, forced honesty that came too late to preserve his reputation. Within 1 week of the settlement agreement, I'd launched Reynolds IP Law, taking the committed clients and their patent portfolios. The transition was remarkably smooth. I'd prepared thoroughly, securing office space, hiring support staff, establishing technology systems, and obtaining professional insurance. The day after the settlement, I opened my doors as an independent patent attorney. The response from clients was overwhelmingly positive. They expressed relief at continuing to work with me directly without Michael's interference. Several clients told me they'd been frustrated with Michael's minimal involvement and were glad to work solely with the attorney who actually understood their technology and handled their patent work. "Jessica, I'm so glad you're starting your own practice," one biotech CEO told me during our first meeting. "Honestly, Michael barely understood our technology. You're the one who's been protecting our innovations all along. We're excited to continue working with you without the confusion about who's actually handling our legal work." Junior associates from Michael's firm contacted me privately within days, asking to join my practice. They said they'd known Michael was claiming my work and found it professionally disturbing. They wanted to work under honest leadership where contributions were acknowledged accurately and professional ethics mattered. Several became my first hires, bringing their talent and integrity to the new firm. "I've wanted to tell you for months that what Michael was doing was wrong," one associate, David, told me during his interview. "Watching him claim credit for your prosecutions while we all knew the truth was demoralizing. I'm excited about working somewhere where excellent work gets proper recognition." The practice flourished immediately beyond my expectations. Without Michael's interference and credit theft, I implemented client service based purely on excellent patent work and honest communication. Clients appreciated the transparency, the direct access to the attorney actually handling their matters, and the technical expertise I provided. Word spread quickly in the biotech community about my new practice. Revenue exceeded my projections within the first 3 months. The combination of committed client portfolios and new business from referrals created strong financial foundation. By 6 months, the practice was substantially more profitable than my compensation at Michael's firm had been, even accounting for overhead and startup costs. The financial success validated the decision to leave and proved that clients valued my actual expertise. Referrals increased exponentially as my reputation spread through professional networks. Scientists I'd worked with recommended me to colleagues. Biotech executives told other companies about my technical expertise. Patent attorneys who knew the truth about Michael's fraud began referring clients to me, wanting to support honest practice. My calendar filled with new client consultations and patent matters. But Michael's firm told a very different story. He attempted to continue the practice after I left, but it failed within a year. Once clients learned the truth about who had actually handled their patent work, most transferred to other firms. The biotech clients who'd been the firm's revenue foundation all left, following either me or finding other counsel. The IP community learned about Michael's fraud through professional networks and informal communications. Word spread that he'd built his reputation on stolen work, that his claimed biotech expertise had actually been my contributions, that his conference presentations had presented my innovations as his knowledge. His reputation collapsed under the weight of revealed truth. Patent attorneys who'd attended his conference presentations felt deceived and angry. Clients who'd hired the firm believing Michael was the expert felt misled. Professional associations that had given him speaking opportunities felt used. The accumulated resentment from years of fraud created comprehensive professional isolation. No one wanted to work with an attorney exposed as having built his career through systematic deception. Michael tried to rebuild his practice focusing on software and electronics patents, his original areas before my biotech work. But even in those fields, his reputation was damaged. The fraud revelations made people question all his claimed expertise. If he'd lied about biotech knowledge, what else had he misrepresented? The erosion of trust was complete and permanent. Within 18 months of our separation, Michael's firm closed completely. He couldn't sustain a viable practice without the biotech revenue I'd generated and with his destroyed reputation. I heard through professional contacts that he'd taken a corporate in-house position, leaving private practice entirely. The career he'd built on stolen work had collapsed when the truth emerged. 5 years after launching Reynolds IP Law, the firm was recognized as a leading boutique patent practice for biotech and pharmaceutical clients. I'd secured hundreds of patents protecting innovative therapies, diagnostic technologies, and medical devices. My technical expertise and prosecution skills had earned respect throughout the IP community. The recognition I deserved finally arrived with proper attribution. The professional achievements were gratifying, but the personal vindication meant more. For 3 years, I'd watched Michael claim credit for work I'd done, presenting my expertise as his knowledge, building his reputation on my stolen contributions. Now the truth was public and permanent. The IP community knew who had actually developed those prosecution strategies, handled those complex patents, built that biotech practice. I published articles about patent strategy in leading intellectual property journals, sharing the techniques I'd developed over years of prosecution work. The publications established my expertise publicly and provided resources for other patent attorneys. I received invitations to speak at conferences, presenting my actual innovations without someone else claiming them as their work. I also began advocacy helping other attorneys, particularly women, protect themselves from exploitative partnerships. I'd learned painful lessons about credit theft, billing fraud, and professional manipulation. I wanted to help others recognize warning signs earlier and protect themselves more effectively than I'd initially done. I developed resources about billing documentation, client relationship management, and recognizing credit theft. I created guides explaining professional ethics rules about honest attribution and fee arrangements. I wrote about partnership agreement provisions that protect junior attorneys from exploitation. These resources, freely available on my firm's website, helped attorneys across the country protect themselves. I also offered pro bono consultation to attorneys facing similar exploitation. Young lawyers, especially women, contacted me describing situations that mirrored my experience with Michael. Senior partners claiming their work, taking credit for their client relationships, preventing them from establishing independent reputations. I helped them document the fraud, understand their legal options, and plan strategic responses. One young patent attorney, Maria, contacted me after reading my published articles about professional ethics in law partnerships. She described a situation eerily similar to mine. Her senior partner was claiming credit for pharmaceutical patents she'd prosecuted, presenting her technical expertise as his knowledge, preventing her from receiving proper recognition. "I've been documenting everything like your articles suggested," Maria told me during our call. "But I'm scared to confront him. What if I'm wrong about how serious this is? What if challenging him destroys my career?" I shared my experience honestly, explaining both the difficulty and the necessity of addressing systematic fraud. "The documentation you're gathering is crucial," I told her. "When you have comprehensive evidence, you have leverage. But more importantly, you have truth. Don't let fear of confrontation keep you in a situation where someone builds their career on your stolen work." Maria eventually left her exploitative partnership and launched her own successful pharmaceutical patent practice. She credited our conversations with giving her courage to act and guidance about how to do it strategically. Helping her and others like her became one of my most meaningful professional contributions. I also worked with bar associations to strengthen ethics guidance about partnership exploitation and credit attribution. I presented at professional responsibility conferences about recognizing and preventing systematic credit theft in law firms. I advocated for clearer rules about billing honesty and origination credit allocation. These advocacy efforts created systemic changes that helped protect other attorneys from experiencing what I'd endured. Bar associations began emphasizing partnership protection in their ethics training. Law schools started teaching students about recognizing exploitative partnerships and documenting their contributions. The professional culture gradually shifted toward greater honesty and accountability. 7 years after launching my independent practice, I received recognition from the Intellectual Property Law Association for both patent excellence and advocacy for professional ethics. The award honored my technical contributions to patent prosecution and my work helping other attorneys protect themselves from exploitation. Standing on stage accepting the award, I felt profound validation. The award ceremony included a video presentation highlighting my career achievements and advocacy work. It featured interviews with clients praising my technical expertise, colleagues discussing my professional integrity, and young attorneys describing how my guidance had helped them navigate difficult partnership situations. The recognition confirmed that transforming my exploitation into systemic improvement had created lasting impact. During my acceptance speech, I spoke honestly about the credit theft I'd experienced and how it had motivated my advocacy work. I wanted young attorneys in the audience to understand that exploitation wasn't inevitable, that they could protect themselves through documentation and courage. I wanted senior attorneys to recognize their responsibility to acknowledge contributions honestly and build ethical partnerships. For 3 years, a senior partner built his reputation on my work while preventing me from receiving deserved recognition, I told the assembled attorneys. The experience was professionally devastating and personally painful. But it taught me the importance of documentation, the power of truth, and the necessity of ethical practice. I hope my experience helps others recognize exploitation earlier and respond more effectively. The speech resonated throughout the IP community. I received messages from dozens of attorneys sharing their own experiences with credit theft and thanking me for speaking publicly about professional misconduct that often remains hidden. The conversation helped break the silence around exploitation that enables it to continue. Today, Reynolds IP Law operates with a talented team serving innovative biotech and pharmaceutical companies across the country. My patent work has protected billions in innovation value for therapies treating cancer, genetic disorders, infectious diseases, and neurological conditions. I've built the career I envisioned through excellent legal work and absolute integrity, with proper attribution for every contribution. The firm culture emphasizes honest attribution and ethical practice. Junior attorneys receive full credit for their work, their names appear on patent filings, clients know who actually handles their matters. I mentor associates actively, helping them develop expertise while ensuring they receive recognition for their contributions. The transparency creates trust and excellence. But the most meaningful outcome extends beyond my personal success. Bar associations now emphasize partnership protection and credit attribution in their ethics guidance more strongly than when I started practicing. Young attorneys have better resources for recognizing and addressing exploitation. The professional culture has shifted, however slightly, toward greater honesty and accountability. Law schools now teach students about documenting contributions, recognizing credit theft, and protecting themselves in partnerships. Professional responsibility courses include case studies about systematic fraud in law firms, using situations like mine to illustrate how exploitation operates and how to combat it. The educational improvements help prevent future attorneys from experiencing what I endured. That's the ultimate outcome when systematic fraud meets someone skilled enough to succeed independently and committed enough to expose the truth publicly. Michael Jong destroyed his legal career through his own dishonesty, losing everything he'd built on stolen work when the truth emerged. I built a successful practice on the patent work I actually performed, protected by clear documentation and client loyalty to the attorney who genuinely protected their innovations. The IP community learned that professional fraud has serious consequences, that stolen credit ultimately collapses when truth emerges, that integrity matters more than convenient misrepresentation. Those lessons benefit every attorney who practices honestly and every client who deserves truthful representation about who actually handles their legal work. My story validates that patience, documentation, and strategic action can overcome even systematic professional exploitation. That junior attorneys don't have to accept senior partners stealing their work and credit. That clients deserve honesty about who actually provides their legal services. That professional communities can and should hold members accountable for fraud. The truth came out, completely and permanently, destroying the fraudulent reputation built on my stolen work while establishing my legitimate expertise. That truth protects not just me but every attorney who refuses to let their contributions be stolen and every client who deserves honest representation. The accountability serves justice and strengthens the profession we're all part of.